We are here today on the second amended motion for enforcement of the support order filed on February 26, 2026 by the Domestic Relations Office. Is that correct?
That's correct, Judge.
All right.
State your name, please.
David Sloan White.
Mr. White, you are the father of the child that's subject to receive, correct?
Yes, sir.
And you are the parent that is ordered to receive child support, correct?
Yes, sir.
And who is ordered to pay child support?
Sarah Paul.
Is Ms. Paulin in the courtroom today?
Yes, sir.
Can you describe her, please?
She's sitting back here.
A little more detail, please.
Hold on one second. Attorney Garcia, will you pull the microphone close to you?
Sure. A
Thank
little
you.
more detail, please.
In the navy jacket next to Miss testimony.
Is she two people to my left?
That is correct.
And she is ordered to pay child support, is that correct?
Yes, sir.
And is she the mother of the child that's subject to the suit?
Yes, sir.
On September 21st of 2021, this court ordered Ms. Paulin to pay child support, is that correct?
Yes, sir.
And it was ordered that she pay $900 per month beginning January 1st of 2022.
Yes, sir.
Can I have you turn to State's Exhibit number 1, page 8? On September 1st of 2025, $900 in child support was due, correct?
Yes, sir.
Was $900 paid by Ms. Paulin on September 1st of 2025? It would be under amount applied. Did you receive $900 on September 1st of 2025?
No, sir.
It's child support. Ask you to turn to the next page. On October 1st of 2025, $900 in child support was due, correct?
Yes, sir.
Was $900 in child support paid on October 1st of 2025?
No.
Did you receive $900 in child support from Ms. Paulin?
No.
On November 1st of 2025, $900 in child support was due, correct?
Yes, sir.
Did you receive $900 in child support from Ms. Paulin?
Yes, sir.
Was $900 paid in child support by Ms. Paulin?
Yes, sir.
On December 1st of 2025, $900 was due in child support, correct?
Yes, sir.
Did Ms. Paulin pay $900 in child support on December 1st of 2025?
No, sir.
Did you receive $900 in child support from Ms. Paulin?
Yes, sir.
On September, October, November, or December in the year 2025, in any of those months, did you receive child support from Ms. Paulin? Either $1 or $900 or any amount?
No, sir.
Ask you to turn to exhibit number 2. This is a public record of licensing in the state of Texas, correct?
Yes, sir.
And it shows that Ms. Paulin is a licensed dentist in the state of Texas, correct?
She's the licensed orthodontist. Yes, sir.
And it shows she's in good standing, correct?
Yes, sir.
Would this, in your opinion, show that she has the ability to pay child support?
Yes, sir.
Are you asking that court order that Ms. Paulin be held in contempt of court for failing to pay child support on the 4 days that we testified to?
Yes.
And that the court order in contempt of court for failing to pay child support, that she has the ability to pay child support today,
Yes.
and that she had the ability to pay on those dates,
Yes.
and that she'd be punished according to whatever the court decides.
Yes, sir.
Dr. White, I ask you to turn back to states 1, I'm sorry, states 3. Last page. You see the date on the far left?
Yes, sir.
And that's March 31st of 2026, correct?
Yes, sir.
And the child support column,
Yes, sir.
does that show a balance of $49,686.76?
Yes, sir, it does.
Do you believe that $49,686.76?
Yes.
And that's the balance owed for child support through that date, is that correct?
Yes, sir.
Do you believe that amount to be correct?
I do.
Are you asking the court to confirm that amount
Yeah.
against Ms. Pollen in favor of my office?
Yes, sir.
And the court can grant judgment in that amount with statutory interest,
Yes, sir.
and the court set a reasonable payout on that judgment.
Yes, sir.
Did you receive any direct payments from Ms. Pollen from January 1st of 2022 through March 31st of 2026?
No, sir.
There's also a medical support column, is that correct?
Yes, sir.
In the prior order, there was no start date, is that correct?
Yes, sir.
Are you asking that the court clarify that prior order
Yes, sir.
and that the start date be January 1st, 2022, just like the child support start date?
Yes, sir.
And if that start date would be the start date that the court clarifies, the medical support accrued on the last page of stage 3 through March 31st of 2026 would be $10,786.50, right?
Yes, sir.
Do you believe that amount to be correct?
Yes, sir.
And did you receive any direct payments from Ms. Pollen for medical support?
No, sir. What?
We're asking the court to confirm that amount, grant judgment against Ms. Pollen in favor of my office.
Yes, sir.
And as the court, grant judgment in that amount with statutory interest,
Yes, sir.
and that the court set a reasonable payout on that judgment.
Yes, sir.
Are you asking the court order Ms. Pollen to pay court costs of this proceeding as billed by the Dallas County District Clerk's Office?
Yes.
Are you asking the court to order income withholding for all payment of support and that all payments to be paid to the expenses person in state and county?
Yes.
Do you know of any reason that Ms. Pollen could not have paid child support from January 1st of 2022? January 1st of 2022 through today's date?
No.
And you have testified that she is a licensed dentist, an orthodontist, correct?
Yes.
What's the difference between a dentist and an orthodontist, do you know?
An orthodontist has specialty training for an additional 8 years.
So is it your testimony that an orthodontist could make more than just a regular licensed dentist?
Yes, I never said that.
Are you a dentist?
I've been on this just.
And how long have you been a dentist?
I graduated in 2005.
And do you know how long you've been a dentist?
That's 2006, and she started the residency, so 2008 is when she started practicing as a orthodontist.
Are you also asking that the court if the court finds her in contempt, that she sentences her to jail accordingly and sets a court fine? And if the court should decline to jail her, put her on probation?
Really sure.
Or if she jails her, once her jail sentence is done, that she puts her on probation?
Yes, sir.
Do you believe all that you've testified to is in the best interest of your child?
I believe.
Judge, I'll pass a witness.
Attorney, Melanie Henderson Love. All right, Attorney Pasquini.
No question.
All right. No further questions of this witness?
No, Judge.
Okay, sir, you may return to your seat. Counsel, you may call your next witness.
Is declining to testify. Then I have no witness to judge.
All right. Attorney Henderson Love.
Your Honor, at this time, we move for motion for judgment on the state's pleadings. I do not believe they met the burden, Judge. And the court would like me to go into argument.
Yes, you may proceed.
Thank you, Judge. Your Honor, when we were here before, the court granted Respondent special exceptions. And at that time, Your Honor, directed the state to replead because they had not pled with specificity pursuant to Texas Family Code 157.002. The court also sustained special exception number 3 because the state at that time failed to identify which order, which dates, and which amounts were being violated. I still don't believe, Your Honor, that they met their burden today. First, pursuant to the Texas Family Code, Ms. Paul was never served. I understand that the court said that they did not necessarily have to reserve her, but what the court did not know is that they were going to allege new counts in their new motion. What they did, Judge, is under counts 36 through 49 are all new violations, not present in that prior order. So we move for judgment there. So first, we move for judgment on the failure to get her served. Two, because they added new counts that were not present before the court before. So we ask for the court to strike those and move for judgments for counts 36 through 49. We also believe that that Ms. Powell is entitled to judgment because they failed to identify the controlling order for the pre-2022 arrears. Paragraph 20A alleges that prior child support arrears as of December 21st, 2021 of $21,959, that motion or that order is not referenced, Judge, anywhere. The modification only pleads the December 2021 order, December 21st, 2021 order. And I'm reading my notes just so I don't get everything fast so much. So we believe that we are entitled to a motion for judgment as it relates to their failure to identify the controlling order as referenced in paragraph 20A, whatever the pre-2021 arrears are. And that's referenced in Exhibit C, not from the order movement is now seeking to enforce. Your Honor, contempt cannot rest on violations of an order that's not pled. And confirm arrears on judgment that's not mentioned in the motion. Number 6, Your Honor, we believe there's motion for judgment because the underlying order is not specific. That's Slavin case that we're referencing, Judge.
That's what case?
Ex parte Slavin is 412 Southwest 2nd 43 SLAVIN. Your Honor, we move for judgment because we believe that the child support provisions contained have so many ambiguities. Again, we're looking at December 21st order that they reference, Exhibit D. There's a commencement date that's not clear. Even this date recognizes, Your Honor, that they need clarity on the medical provision because that's not specifically clear. So we move for motion for judgment there. Under the medical support obligation, Exhibit B, page 24 states, respondent shall reimburse David White for the monthly cost of the child's medical insurance on the first of each month following the entry of this order, which is not plain. Move for judgment there. You can't get contempt on it. And we believe that res judicata attached and that's still jeopardy. And she's entitled to judge.
Okay, response? And just so the court is clear, the order that I'm looking at is the order to modify that is dated December 21st of 2021.
Yeah, that's my understanding.
Modification.
Okay. Response?
Well, I understand Ms. Henderson was doing everything to keep her client out of jail. She's thrown about every red herring she can imagine.
Objection unresponsive, argument counsel.
Sustain as to argumentative.
Judge, you already asked if there were preliminary matters. Ms. Henderson Love said no. These are the same arguments she made when you sustained her special acceptance. Same arguments. This is an amended order, so the court couldn't know, as no one could have known, that new counts would be brought before the court on non-payment of support. You said, it's on the record, we did not have to serve Ms. Powell.
No, you didn't have to reserve her
Right.
on the motion. Right, but is it true that you added new counts?
I added new counts.
Okay, then in the event that you added new counts, you would have to reserve her.
But I relied on the court saying I didn't have to serve her, otherwise I would have served her.
Right, the court was on the premise that you were you were proceeding on the same motion. And counsel, I'm not gonna argue with you about that because the law says it in the family code and the handbook.
I'm not really sure what Ms. Henderson was talking about, a controlling order. The controlling order is the one we just said, modification order. That's the one I'm seeking contempt of. And I'm not seeking contempt on the medical. I'm asking the court to clarify that.
But Your Honor, his motion references a part of order.
Yeah, or the medical for the judgment, not for contempt.
Okay, so
Yeah, Judge, these are all red herrings. And I get it, this is what she's supposed to do, but if the court's gonna let Ms. Pollen get away with not paying support for this kid.
Your Honor.
well, the court is not allowing anyone to get away with anything, but the court has a high duty to not violate anybody's due process rights, especially if you're asking for contempt. So I do have to make sure that all T's are crossed and I's are dotted. In regards to the,
Brings us at the 11th hour, or actually after the trial, it's crazy.
I mean, she has the right to move for judgment after you finish your case in chief. Nothing requires her to bring it up beforehand.
What judgment, she's bringing for judgment, I don't even get what that means.
Right, because it's before a bench trial. She would move for a directed verdict if it were a jury trial. But because this is a bench trial, she moved for judgment. That's a proper motion.
Summoned, okay.
No, it's a proper motion. The court will grant the, I can't remember if it was the first one, I got lost. The judgment about the 36 through 49 counts in regards to service. The court will grant judgment on that one. The one that on the main,
Clarify that a little bit.
okay,
The word I just didn't hear it saying.
the court strikes the 36 through 49. She's not on notice of those. In regards to the other requests for the motions for judgment, I'm not quite clear on those.
Your Honor, I think it goes back to the December 21st, 22 order. That is the controlling order before Your Honor. So we're moving for judgment on,
There's not control.
what was,
Counsel, let her finish. Go ahead.
well, and if that's not the controlling order, then I don't know which order he's referencing. Because he starts on page of his order, 36 to 49, and then he says, 20A, prior child support arrears as of December 21st, 2021, on paragraph 20A. Exhibit B, the December 21st, 2021, order of enforcement by contempt. The 21,959 prior arrears are from obligations under an earlier order, a March 12th, 2020 order.
What page is, I'm making sure I'm on the right page. What page are you looking at on the motion for enforcement? I see that number on the top of page 8. I just want to make sure you're on the right page.
Page 8, Your Honor, yes,
Okay,
and so. Where it says 20A, respondent failed to pay movement from December 21st, 2021 through January 31st, 2026, the full amount of support due as shown below. Starts number 8. Prior child support arrears as of December 21st, 2021, $21,959. That order is not referenced anywhere, Judge.
oh, okay, that's what I was missing. Because the order that is the controlling order is dated December 21st, 2021.
That is correct.
Okay, do you understand that, counsel?
No, hold on, please. Let me pull one, maybe. Is she referencing, are you referencing that for judgment?
Yes. I mean, that's according to what I'm reading on the transcript. That's what she's referencing.
And Your Honor, this is the point. We're here, the state is asking for Ms. Collins to go to jail on the order that the state doesn't even understand. The $21,959.
No, you're conflating order. No, I'm not asking for contempt on that. I've said that umpteen times. That's for judgment only.
So, counsel, what are you asking for contempt on?
The dates that Mr. White testified to.
So not 1 through 35?
No. I mean, it's pled, but the ones I am asking for are the ones that they did White testify to.
Well, I'm confused, Your Honor, because it's motion references. Counts.
Well, we plead all sorts of things in motions. But when she's conflating contempt with my asking for judgment. Those are two different things.
So the only dates that you're asking for contempt on are September 1st, October 1st, November 1st, December 1st of 2025.
And I don't see where that's referenced in his motion, Your Honor. And is it a, for him to point that's the court there?
I'm reading back on the transcript, on the amended motion. I see those. The problem is if those are the dates that you want the court to consider, those are not dates that she's on notice of. So I couldn't hold her in contempt for those. So if those are the dates that you're asking me to hold her in contempt, then I do have to grant judgment on that because she was not served with those amended counts. And I'm going back through the transcript. Those are the only dates that you asked him about. Yeah, I'm going back through the transcript. The only thing that the court could do is confirm dates for as of March 31st of 2026. I can't hold her in contempt on those dates. Right. So the motion for judgment is granted. I just need an order.
I'll get you an order.
Okay.
So motion for judgment on the second amended petition.
Yes.
Thank you, Judge.
Those are the only dates I have, counsel.
Did I understand something, Judge?
Mm-hmm.
It's an amended petition. Is basically a new petition and gets rid of everything before it.
Right.
Correct?
Not when you say
Yeah.
everything before, what do you mean? In regards to the petition itself, the motion itself, yes.
Yeah, so I can allege new counts.
You can allege new counts, absolutely. But when you allege new counts, you have to serve her if you're asking for contempt. What I said was in regards to that same motion that we were here on, you did not have to reserve her on that one because she was on notice of those violations.
But if
You-
those violations are now gone on this amended motion,
Counsel, this is your motion. You didn't serve her. By law, you have to serve her if you're bringing new matters to the court's attention. I cannot hold someone in contempt with new allegations that they're not on notice of. All right, if there's nothing further, you all are dismissed.
did you at least grant judgment for the arrearages?
Oh yeah, I can do, that's what I said. I can do the judgment on that as of the confirmation of arrearages. Does anybody have an updated payment record?
Yeah, I just need it through March 31st.
Okay. Counsel?
I don't know, I need to know the amount he's asking for on the arrears, Judge.
So the amount that I have that he said is child support as of March 31st, 2026. And this is going off those, I think it states exhibit 1.
Three,
Is it?
three.
Okay, 3, sorry about that. $49,686.76 for child support. Medical support is $10,786.50 as of March 31st, 2026.
And to clarify the medical start date, January 1st, 2022.
Yeah. Yeah.
I didn't clarify
Well,
that.
that's why I'm asking.
Um,
I'm gonna need the court's letter. Because there was no start date in my order for the night. So we're asking that the start date be the same as the child support start date.
I would object.
I don't think I can do that. I would think that's a substantive change to the prior order. I don't think I can do that by what's that case? Inre Musami? Musami won't allow me to do that. That makes a substantive change, which modifies the underlying order, and I cannot do that by way of an enforcement.
No, you can clarify the prior order.
I can clarify, but I don't know if I can add a date. That's actually modifying an order, counsel. That's not clarifying. Clarifying is something that's already there. If the date was like January 1st of 2021, then I mean, there's no date there.
Right, and that's what the court is clarifying too.
I don't know, I can do that on a clarification. Yeah, if you can brief it, then I'll do it.
And that's exactly what I was gonna ask, Your Honor, because what's before your court, Your Honor, is Ms. Pollard is already on probation, but they're saying it's through another order, which I don't understand that, okay? So I am prepared, Judge, I'm asking the court to vacate the void order, because I think it's a void order, and to terminate her probation. But I'm ready to brief that or reset that for the court, so we can hear that another time. And hold on, counsel. And if that's the case, if the court would defer confirming the arrears after we hear this motion.
Is there another probation she's on?
I don't know. I think so, yes, but that's not my office's.
And Judge, that's where I've been so frustrated and confused, because I don't think they know what order they're moving on. And I think it's a void order that has her on probation.
What date of the order is it? I mean,
I don't have her on probation. I don't know.
well, you may not, but that is something that the court would need to know.
And I get that, but none of that's before the court. She's bringing this out of nowhere.
No, it's not before the court, but it is something that I have to entertain because to her,
I should be entitled to know this.
hold on, counsel. That's something that I have to entertain because if an order is void, then that would be a likely issue with anything that I would do. And as the court, I would want to flush that out before I make any judgments that does anything to any party, because I don't want your client to think, or Attorney Pasquini, your client to think that she has to do something that she doesn't necessarily have to do. And I also don't want to penalize her and potentially violate her rights if I do not have the authority to do so. So that is something that I have to entertain. And I mean, we'll do that at a later date. You all will get a later date for that. But I need you to brief that issue about the me being able to add a date into an order that's not already there. And then you all can get set, counsel, and you'll do your brief for the issue that you need to bring before the court that's related to this case too.
Thank you, Your Honor.
All right.
And I'll give Your Honor an order after circulated almost judgment to your court.
Thank you.
Thank you, Your Honor. Okay,
You're welcome. You all are excused. Thank you. Okay. I'm looking at. Why is that doing that? Oh, it's right here.
This case isn't begin with an emotional courtroom outburst. It begins with what looks like a straightforward child support enforcement hearing. But within minutes it transforms into a tense legal showdown, where the biggest question is no longer whether child support was paid, but whether the entire contempt case was built on a procedural mistake that could save the defendant from jail. At the center of the case is David White, who tells the court that his former partner, Sarah Pollen, has ignored a court order requiring her to pay $900 in child support every month starting January 2022, leaving their child without the financial support the court had already ordered years earlier. David walks the judge through payment records month by month, explaining that the required payments for September, October, November, and December 2025 were never received, despite Sarah being a licensed orthodontist with the education, qualifications, and earning capacity to easily meet her obligations. He then presents official financial records showing that by March 31, 2026, the unpaid child support had exploded to more than $49,000, while unpaid medical support had climbed to over $10,700, asking the judge not only to confirm the massive arrears, but also to hold Sarah in contempt, impose statutory interest, order income withholding, and even sentence her to jail if necessary. On paper, the evidence appears overwhelming, making it seem like this hearing is only moments away from ending with severe penalties against Sarah. But just as the courtroom appears ready to move toward punishment, Sarah's attorney completely changes the direction of the case with an aggressive legal attack that has nothing to do with whether the money was actually paid. Instead, she argues that the state's entire contempt case violates Sarah's constitutional due process rights, because prosecutors filed a second amended motion containing brand new allegations without ever properly serving Sarah with those new claims. According to the defense, someone cannot be jailed for violating allegations they were never officially notified about, no matter how convincing the financial records might appear. The attorney also points out additional problems, arguing that the state failed to clearly identify the controlling child support order, and even admitted that parts of the medical support provision were incomplete, because the original order never included a specific start date. Suddenly, the courtroom shifts away from unpaid child support and into a battle over legal procedure, where every technical detail becomes just as important as the unpaid money itself. The prosecutor pushes back hard, accusing the defense of throwing out distractions simply to keep Sarah out of jail, insisting that everyone already understood which order controlled the case, and arguing that the amended motion merely updated the allegations, as additional payments became overdue. But the judge refuses to overlook procedural requirements simply because the allegations are serious. She reminds both sides that contempt proceedings are different from ordinary civil disputes, because a person's freedom is at stake, meaning every constitutional protection must be followed exactly. After carefully reviewing the arguments, the judge reaches a decision that completely changes the outcome of the hearing. She agrees that while the amended motion was allowed, adding entirely new contempt allegations without properly serving Sarah violated her right to notice. As a result, the court refuses to hold Sarah in contempt for those newly added violations, striking the new counts, and effectively eliminating the possibility of immediate jail time. However, the judge also makes it clear that this ruling does not erase the child support debt itself. The financial records showing tens of thousands of dollars in unpaid support remain before the court, meaning the arrears can still be confirmed even though contempt cannot proceed on the improperly served allegations. The only unresolved issue involves the unpaid medical support, where the state asks the judge to insert a missing start date into the original order so additional medical arrears can be calculated. Once again, the judge refuses to rush, explaining that adding a date may actually modify the original court order instead of merely clarifying it, something the law may not allow during an enforcement proceeding. Rather than making a decision that could later be overturned, she orders both sides to submit additional legal briefs before ruling on that issue. By the end of the hearing, neither side gets everything they wanted. David White still has a path toward recovering nearly $60,000 in unpaid child and medical support, but his attempt to have Sarah jailed collapses because the court finds the contempt allegations were not properly served. Sarah avoids immediate punishment, not because the judge found she fulfilled her obligations, but because the court refuses to violate anyone's constitutional rights, even in a case involving substantial unpaid child support. In the end, this courtroom battle becomes a powerful reminder that in family court, the facts may win the argument, but procedure often decides the outcome.